We handle a significant variety of claims within this practice group. We do design defect claims where we defend architects and engineers who get brought into litigation based upon building failures and whatnot. We also represent contractors and subcontractors, often in payment dispute issues. And we also represent owners in connection with problems with various commercial and residential building projects. It was in the course of working with Loy Waldrop. So if you don't know who Loy Waldrop is, he was my mentor, recently retired, probably the best construction attorney in Tennessee that's ever lived. Kind of the godfather of construction law in Tennessee. And one of the things that we started noticing as we were handling more and more cases for owners, particularly in residential, but it crosses over into commercial projects as well. We started seeing about 5 or 6 years ago more and more instances of unlicensed contracting. It's not an area of the law that had been really covered a whole lot, but it's actually pretty interesting, and it can be very consequential, which is why I've subtitled this presentation "Avoiding the Big Mistake." So we're going to talk a little bit about that today and come at it from a couple of different angles. If there's any questions, I'm sorry that we're not able to answer those, like ask me those directly over the audio, but if you'll put those Q&As in the chat, then I'll try to get to those at the end. I expect that the presentation might last 30, 35, 40 minutes, something like that. So I should have time for questions at the end. So with respect to unlicensed contracting, one of the rules that Loy always talked about, Loy had certain rules. They were called the Waldrop rules. And the Waldrop Green rule was to make sure that you get paid for the work that you do. And it seems kind of obvious that would be important. Common sense dictates that contractors can't operate a successful business if they don't end up getting paid for their work. But being an unlicensed contractor in Tennessee, as we're going to see, and also in other places, can just have a huge impact on a contractor's bottom line and their ability to get paid both now and later. And so the thing that's so surprising to me is how often we're seeing the issue of unlicensed contracting and who we're seeing it from, because I think that most people, if you're thinking about the concept of unlicensed contracting, the most obvious example is it's a contractor that doesn't have a license. And that is certainly true. We see a lot of those cases and instances, but you can also be a licensed contractor, but be found to be unlicensed for a particular project for a variety of reasons. And we'll cover some of those as well. We see this all the time. And it can have really important effects for both owners and contractors, as we're going to see. So what constitutes contracting? And I guess that's the first most simple undertaking. What you need to know is in the state of Tennessee, contracting is defined extremely broadly. And what I've put here on this slide is basically the definition part of the statute from the Contractor Licensing Act of 1994. And if you just kind of go through it, you can see how many different activities. Most people think contracting, and the idea is, well, when you enter into a contract for somebody to build a building for you, the act of entering into that contract is contracting if they're going to build something for you. But it's so much more broad than that. Just starting out, undertaking to, attempting to, or submitting a price or bid. Bidding, pricing constitutes contracting in the state of Tennessee. Attempting to contract, attempting to put in a bid constitutes contracting. Offering to construct, supervise, superintend, oversee, schedule, direct, or in any manner assume charge of the construction. So it's not just that you're going to furnish all the materials. It could be that you're just going to supervise or oversee or schedule things. All of these activities constitute contracting. And it doesn't matter if you're talking about, it doesn't have to just be a structure. You can see it talks about assume the charge of a construction, alteration, repair, improvement, movement, demolition, putting up, tearing down, or furnishing labor to install material or equipment for any building, highway, road, railroad, sewer, grading, excavation, pipeline, public utility structure, project development, housing development, improvement, or any other construction undertaking in which the total cost is $25,000 or more. So the only real exception to that is masonry work, which is, has to be $100,000 or more for labor and materials in order for the masonry contractor to need to be licensed. But anything else that relates to construction, over $25,000. So, if you've got somebody that you want to hire to work on your basement, if you're going to end up paying them, more than $25,000 in materials and expenses, they really have to be licensed to be able to do that work. So, that's kind of the dividing line between something that's handyman type stuff and then needing a contractor license is $25,000, which is why you'll see sometimes some of these handyman companies will have disclaimers and say, that you agree that the value is less than $25,000 for the project. We see that sometimes, and that's because those people are actually aware of this statute and the fact that they have to be licensed in order to do that job. But the key point of this is just how easy and how broad contracting is in Tennessee, which is a surprise to some people. I know it's been a surprise to some contractors that I've dealt with over the years too. They didn't think that what certain activities they were doing were considered contracting when actually they are. So who has to be licensed? Well, Tennessee law requires all persons who perform the services of a contractor to obtain a license prior to furnishing such services. So, there could be a situation where a prospective contractor says, well, I know of a particular project that's coming up that I want to be involved in, and I'll go ahead and prepare my bid, put my bid together on it, and then if I get it, then before the work starts, I'll make sure I get my license. It doesn't work like that. You've got to be licensed before you put in your bid, or even attempting to put in your bid. Or attempt to give pricing information. You have to be licensed. Also, the term contractor is broadly includes, the prime contractor, electrical contractors, subcontractors, mechanical subs, plumbing subs, masonry subs. All of those have to be licensed. And if the value of the project, again, is over $25,000 and $100,000 for masonry work, then the contractor must be licensed. It's also important to note that if somebody wants to be a construction manager, that gets back to the previous definition of supervising, superintend, overseeing. Construction managers have to be licensed as a contractor in the state of Tennessee as well, if the project is over $25,000. So there's a lot of things you have to do. If you're going to be involved in a project, you need to know you need to be licensed. Why is it important to be licensed? Well, and this is the one that gets people all the time. And I've got my monopoly guy here about going to jail. First and foremost, it is against the law with criminal penalties to be an unlicensed contractor in Tennessee. Contracting without a license is a Class A misdemeanor. For those of you who don't know, the difference is obviously a felony is worse. Felonies are punishable, Class A through E, by 1 year or more in prison, just depending on the class of the felony. And in misdemeanors, classes are A, B, and C, and C being the least amount. So it's as high a misdemeanor crime as you can commit in Tennessee, and it is punishable by up to 11 months, 29 days in jail and or a fine not to exceed $2,500. Now, as a practical matter, I've never seen anybody charged with this crime. Although there's certainly been times where I think a district attorney would be inclined or could easily move forward with it. But it is something that the legislature has put in. The General Assembly for Tennessee has put this in as a potential criminal penalty. It says one also commits a Class A misdemeanor if they accept a bid from an unlicensed contractor, which means that it's technically against the law to accept that bid. That's even less likely to be prosecuted. A lot of times people don't know that they're in, especially on the residential side, especially, people don't realize that they're entering into a contract with an unlicensed contractor. But technically under the statute, it is potentially a criminal penalty. If a person engages or attempts to engage in contracting without a license, Tennessee law provides that they are not eligible for a period of up to 6 months to get their license after a determination of being unlicensed by the Tennessee Board for Licensing Contractors. So if there's a situation where somebody gets caught contracting without a license, they're going to be barred for 6 months from getting that license by the board. Practical considerations about why it's important to be licensed. It's hard to get paid if you're unlicensed. The cases used to be really clear that you just simply had no redress in a civil action. So if you were a contractor that wasn't licensed and you did construction work and sent a bill to the owner and they didn't want to pay you, then you were just out of luck. You couldn't go to court and say, Your Honor, we had a contract. I'm sued on this contract. Well, if you were unlicensed, that was just a complete bar to your recovery, and the judge would just throw the case out. Obviously, that's a pretty harsh result. But now an unlicensed contractor can recover on an action for quantum meruit, but the recovery is still very limited. You can only recover your actual documented expenses proven by clear and convincing evidence. So in the same fact pattern where a contractor now is unlicensed and does work for someone in Tennessee, they don't get paid for their work, so they file suit. They don't get to prevail on their contract and get the profit and the overhead that they would have been entitled to had the contract, been enforceable. Rather, they can only get what they can show are their actual documented expenses. And even then, normally in a civil jury trial, the burden of proof is a preponderance of the evidence. So you just have to show that one side is stronger than the other. For a plaintiff to win, their evidence has to be slightly heavier than the evidence for the defendant, whereas clear and convincing is a much more stringent burden of proof. I don't think that it's quite as stringent as like a criminal matter where there has to be proof beyond a reasonable doubt. But certainly clear and convincing evidence is a much higher burden of proof than a mere preponderance of the evidence. You get no profit as an unlicensed contractor. You get no overhead. And you also have no lien rights as an unlicensed contractor. More troubling even still for the unlicensed contractor is that if you get sued because as a counterclaim, for example, say you were to file suit against somebody that didn't pay you, well, they could counterclaim if you're an unlicensed contractor, and it's a per se violation of the Tennessee Consumer Protection Act for anyone to be an unlicensed contractor in Tennessee and to do work as an unlicensed contractor. So, what does that mean? That means that an unlicensed contractor has a possibility of getting punitive damages assessed against them and treble damages. And there may be personal liability for the contractor, even if acting through a corporation or a limited liability entity. It's basically a per se knowing violation of that statute. And if those damages are found to have been caused by the deceptive act, unlicensed contracting is considered a deceptive act. If it's found to be a knowing violation, there's a good chance that the court will assess punitive damages and treble damages for in favor of the plaintiff. So it's a huge risk to be practicing contracting rather without a license. Ways that unlicensed contractors can be found even where the contractor is actually licensed. So we see this situation sometimes too, where we get involved in a case and the contractor says, well, of course we were licensed. Look, here's our license. Well, you compare the license to what is on the contract and it's two different names. Well, that's a big problem. Here are the ways that an otherwise licensed contractor could be found to be unlicensed for a particular job. One, not being licensed at the time of the bidding. We talked about that earlier, where you thought you would get in your bid, and then if you got it all worked out where you won the job, then you get your license. It doesn't work, and you can't cure that by getting your license later. If it ever were to come up or to be discovered you were unlicensed at the time, then you would basically be stuck with that issue. Another way, allowing the license to expire at any point during the pendency of the work. I've seen the argument made that even a lapse of 1 day during the pendency of a job of the license being lapsed renders them an unlicensed contractor. Losing the employee whose name is on the license. There's a lot of times there's a person who's a dedicated, who takes the test essentially to get the license. You lose that person. Somebody has to, for the contracting entity, has to have passed a contract exam. And if you lose that person, then whose name is on the license, then you essentially become unlicensed if that person's no longer working for you. Not contracting in the correct entity name. We've seen this many times. For example, we had a situation where a gentleman was attempting to contract under his father's license. Let's say that the father's name was David Black, and his son was Walter Black. Well, he couldn't enter into a contract on behalf of David Black by signing Walt Black Construction. It doesn't work like that. Didn't contract in the right entity name, and therefore he couldn't cure that later. He was an unlicensed contractor for purposes of that case. Another way that a contractor could be unlicensed is by exceeding the limitation. Every contract license that's issued in Tennessee has a monetary limitation to it. If you exceed that limitation by more than 10%, you are under licensed. Which is essentially the same as being unlicensed for that particular project. If the amount of your license limit is only $1 million, and you contract with somebody to do work where the labor and the materials are $1.2 million, you have exceeded your limitations of your license by more than 10%, and therefore you run the risk of a court finding you to be an unlicensed contractor if something ever goes south on that project. Which is, can be very distressing. Next issue, so we know that Tennessee protects people, especially consumers, from unlicensed contractors. It's one of the specifically enumerated deceptive acts that are listed in the Tennessee Consumer Protection Act. It's important to note, since we're talking about unlicensed contractors, that there is an exception for essentially businesses who are dealing with each other at arm's length. For example, it is not an appropriate defense for a general contractor, let's say, in Tennessee, to knowingly contract with an unlicensed subcontractor and then at the end say, hey, they're not unlicensed, or they're unlicensed, so I don't have to pay them. Well, there's a case on that going all the way back to 1981 called Gene Taylor and Sons Plumbing Company, where the court held that the policies that bar recovery against a member of the general public do not apply in suits against licensed professionals in the same business. So if you had a situation where the sub didn't enter into the contract in the right name, the courts would view that as more of a mere technicality, as between businesses, licensed professionals dealing with each other at arm's length, whereas it would be more of a problem when you're talking about a member of just the general public or a consumer. Some more language from that case talks about how the statute involved and similar ones are designed to protect the public from being imposed upon by persons not qualified to render a professional service. And the reason for the rule denying enforceability of a contract does not apply when persons engaged in the same business or profession are dealing at arm's length with each other. No reliance was placed upon the existence of a license, as presumptively would be the case if the unlicensed party was dealing with the general public. So that's an interesting judicially created, I might add, exception to the statute. That is not within the statute. That's just courts in the state of Tennessee looking at the statute and saying, yes, we understand the statute, but it doesn't necessarily make sense when certain facts are applied to it. And so they've created a judicial exception. And even though that one was created way back in 1981, it is held up all the way to this day. As far as I know, there hasn't been any case in the last few months that's overturned it, and it had been good for many, many years. So I anticipate that that one will stick around. Talking about unlicensed contracting in Tennessee is one thing, but you know it's important to note that every state that I've dealt with has different laws on unlicensed contracting, and sometimes they can be extremely complicated. And I've put this map on the board. I know that everybody's probably seen enough of maps in the last week or two. There's not just red and blue on this one, though. We've got a lot of different colors. But this, although it says hypothetical, this was actually came from a real case that we had several years ago, and it was just extremely complicated. The lawsuit was filed in Tennessee, which is why we were involved in it. But we essentially got hired by a company out of Oklahoma who was a super subcontractor. What does a super subcontractor mean? For those of you that don't understand what that means, that's basically somebody that a general contractor might hire to basically do an entire project on their own. So the general contractor would get the bid to do the project, and then they would turn 100% of the work over to a super sub, where the super sub would make some money, but then the general contractor would make some money and have final oversight maybe of the actual work. So what you had involved in that case was a situation where the Oklahoma super sub was working for a Tennessee general contractor for an owner that was based out of Arkansas. And the owner was, rhymes with small schmart, but they had a bunch of different stores all across the country that they were renovating. There were projects in Missouri. There were projects in West Virginia, South Carolina, Virginia. And so at some point in time, the general contractor got the bids to do all of these projects in these 4 different states, and they wanted the super sub to come in and do all the work. Now, the super sub was licensed in Oklahoma. They were a licensed Oklahoma contractor, and they could do work as high as in value as they could want to. They were a major construction company in Oklahoma. But they weren't licensed in any of those other states. They weren't licensed in Missouri. They weren't licensed in West Virginia, Virginia, or South Carolina. And so they went to work for the Tennessee general contractor who was licensed in those states. And at the end of the project, the owner was satisfied, but the Tennessee general contractor just didn't pay them a lot of the money that they were owed for doing those 4 different projects. And so the Oklahoma sub hired us to file suit, and we filed suit in Tennessee against that general contractor. And in response to our suit, the general contractor alleged that the super sub was unlicensed in all those other states, and therefore they didn't owe them any of the money that they were supposed to be paid under the contract. Well, we started looking at the laws of the states in those various states, and what we found was really interesting. For example, in South Carolina, there's a statute which is cited here that says licensees, which means licensed contractors, can utilize the services of unlicensed subs to perform work within the limitations of the licensee's license group and the license classification or classification. So without getting too deep into the legalese there, what it's saying is that a licensed contractor can use an unlicensed sub to do work, and that's no problem, provided that the work is within the limits of the general contractor's license group. Well, then there's also another statute in South Carolina that says this: an entity which does not have a valid license as required by this chapter may not bring an action either at law or in equity to enforce the provisions of a contract. So that statute seems to be saying if you don't have a license to do construction work, you can't come into court, either in a court of law or court of equity in South Carolina, and try to sue on a contract. Well, what does that do? It seems to create a clear conflict between two statutes. And our argument was, surely the intent of the first statute is not to let a general contractor hire a subcontractor to do all the work and then simply not pay them. But there was no clear guidance on that issue from any of the courts in the state of South Carolina. Now, it's important to remember the lawsuit was actually filed in Tennessee. And so it was kind of interesting. We got to the point pretty quickly where the judge was looking at this lawsuit where they were moving for dismissal, and all of these different subcontractors, or all of these different states, had law that he was going to have to interpret. So you can imagine the judge probably wasn't too thrilled about the idea of trying to decide issues, potentially even novel issues of South Carolina law, as a Tennessee judge. And so fortunately, he denied the general contractor's motion for summary judgment, so they lost on that. And then once they lost on that, we were ultimately able to settle the case or work it out in a way that was good for our client. But then it was also interesting as we were going through the big project in that matter, the biggest of the projects and the one where the most money was owed was in Virginia, which had, again, completely different type statutes. In Virginia, you have a statute that couldn't be more clear on its face as to what is involved. Quote, no person shall engage or offer to engage in contracting work in the Commonwealth unless he has been licensed. Have to be licensed to engage in contracting. And the case law interpreting that statute indicated that anyone who contracts in Tennessee without a license can't recover anything in any legal proceeding. So you have a situation where you're just SOL if you're an unlicensed contractor in Virginia. You can't file suit, you can't recover at all under their statute. But lo and behold, there's another statute in Virginia that says, and this is a quote, no person shall be entitled to assert the lack of licensure or certification as required by this chapter as a defense if the person who seeks to recover from such person gives substantial performance within the terms of the contract in good faith and without actual knowledge that a license or certificate was required by this chapter to perform the work. So what does that do? Well, that seems to be another clear conflict in the statute. The first statute makes it clear that there can be no recovery for contracting without a license. And then the second statute contains a good faith exception that seems like it's capable of swallowing the whole rule. All you have to do to get around the first statute is to be able to show, oh, well, I didn't know that I had to be licensed to do work in this, to do contracting work in this state. Seems kind of crazy, kind of interesting, but it is one of those things that, just seems to show that, there's a lot of different ways to do things, and there's a lot of different answers to the questions of what's involved with being unlicensed and unlicensed in various states. The key takeaway here that you should remember is that the law in each state is different. Any subcontractor or contractor who does work in a state in which they are not licensed does run a significant risk of not being able to recover. And, that's one of the things that I'm actually pretty proud about is we've been able to help people. I had a big subcontractor contact me a few years ago because they had the opportunity to do a significant amount of work in Florida. So we did some quick research on contracting law, and turned out that, they had already done some bidding. They were unlicensed in Florida. And based on that law down there, they were going to be really exposed if they went ahead and did the work, especially because they had doubts about the contractor that was involved and their reliability for being paid for their work. And so ultimately, they made the decision to turn away from the project and not go forward with it. And it turned out later on, they found out that the subcontractor that did get the project was unlicensed and ended up not getting paid, but about 35–40% of their work. And so that was a situation where we were able to help somebody avoid what would have been a pretty bad outcome had they decided to go ahead and enter into that contract. But what to do about it? If you're a contractor, prudence dictates that if you think you may be operating in an unlicensed contractor, either in Tennessee or somewhere else, you should engage legal counsel. Also, if you're in the middle of a project and you have reason to believe, well, that maybe you've got an issue with your license, such as maybe somebody has left, it's best to contact legal counsel. When I mean somebody's left, maybe the person who's authorized under the license for that particular contractor has left, have to be replaced. So there may be some things that legal counsel can help you with that would avoid some of the more onerous penalties that are involved with that. But it is a very interesting subject. I've got a relatively new case right now where the contractor who was going to build a massive retaining wall at our client's retirement house, and they built it, and then the whole thing ended up falling into the lake, and they're completely unlicensed, and it's just there's real exposure for them, and it could be a catastrophic loss for their company, and of course it was a bad result for my client too. Got a wall down in the lake, but it's definitely an interesting subject with very significant penalties involved. And at this point in time, I would just turn over and find out if there's any questions. I'm going to try to get to the point where I can see who the see who some of the. Doesn't look like we currently have any questions, but I'm going to wait just a second to see if there anybody that has any. Want to just before any questions come in, I want to just say that